with another exciting video. Now, this is actually part two of a video that I did before. So I'm going to tag these videos together. And basically, in this video, the defendant's lawyer is doing all that he can to get his his client's bond reduced. You got to understand the case. They were able to ping his cell phone to a close about location of where the victim was found. Now, with his lawyer is saying, well, you haven't found any burden of proof to say that it was my client who have done this. But what the courts is saying is, listen, we don't want to lower his bond because this was a heinous murder, so to speak. And what the lawyer is coming back and saying in the first case, well, they weren't able to determine that this was actually a homicide. So it was a big back and forth, almost an hour worth of back and forth. And now the lawyer is back with some more of his tactics to see if he can get his client off. So that's enough of me rambling. I'm gonna tag the original video to this just to put it in hindsight. So you'll know that the case that I'm talking about. So if you want to go back and circle the wagon and look at the original case, you definitely can. But nevertheless, this is Antonio with Team Tiggio. Please like, comment, subscribe, as we're going to keep dropping videos on this channel. And once again, we'll see you in the next. We'll see you in the end. See you in the end.
Where are we?
Good, an excellent question. I have been in contact with Corporation Counsel. There is a statute that requires that the property that's posted in the bond be located in Washtenaw County.
Absolutely.
Right. So we do have a property in Washtenaw County. We have an appraisal and it is worth about $4.3 million. It's a commercial property. It is on a land contract, however, but there's only $53,000 and change owed on the land contract, which they are going to pay off this week, is my understanding. So then if the court would reduce the bond from a $2 million, 10% bond, and then we post the property.
Here, I'm just going to stop you.
Okay.
Because I got a full memo and met with Corporation Counsel myself. Here's part of the problem. Part of the problem is that, and the process certainly here, because of certain procedures in Washtenaw County, becomes more complicated. The court cannot hold property in its name.
Correct.
So the property or the securing of the property would have to be in Washtenaw County's name, which, according to the local ordinances here, as I understand them, would be the county acquiring property. For the county to acquire property requires an affirmative vote of the Board of Commissioners.
That's what Mr. Danner told me this morning when I spoke.
That is, and it's that everything he said is absolutely correct. They would have to approve the property in and of itself. If you want to go through that process, I've met the commissioners. They're very nice people. However, I don't think you can do it. It's not going to happen. And certainly this judge in the court won't be joining you in that.
No.
Anyway.
I understand, and that's what Mr. Danner. I did some research and was not able to find any case law that one way or the other, whether the commissioners have to. It seems to me that if the court was satisfied with the collateral on the bond, that I don't know why that the commissioners would have to approve it, as long as the court feels that there's sufficient collateral security and we could just sign it over.
Because if it's collateral, to whatever extent the county, the county is taking an interest in real estate. Since the county would be taking, because the court can, since the county would be taking an interest in real estate, that is the acquisition of property, and the Board of Commissioners would have to approve that.
Okay.
Outside of the fact that then should something happen, I'm not saying that he would, let's say he absconds. The property's there, then there has to be a vote to then go through the process of foreclosing on that property. I just don't see, I mean, certainly the mechanism can happen. I don't think the practicalities are that.
No, I'm concerned about that. The other alternative, and we're still trying to find a bonding agency, but we have not been successful at that. If the court would consider reducing it to $1 million, cash or surety, no 10%.
Can I ask this?
Sure.
The property that you said was in Washington County was worth how much?
$4.3 million.
Okay.
But
So-
there's a $56,000 left on the land contract.
that
So
somebody was going to pay out. So what I don't and can't understand the way that the bond currently is set, and I'm not a bondsman, I'm not clear how they appraise their risk and do whatever. Why couldn't, or why can't that property then be used to secure the bond with the bondsman?
well, I'm working on that, but I have not been successful.
Okay.
That's all. I mean, we've contacted 3 agencies and we have not been successful. But I think if the court would reduce it to a $1 million cash or surety bond, that could be posted. And they would lose 100,000. That would be 100,000 non-refundable to the bonding agency. I think the $2 million has been the problem. So if the court was willing to reduce it to a $1 million cash or surety bond, I think we could get a bonding agency to agree to that. I'm not guaranteeing that, but I think I'm more optimistic than where it is right now. He's been incarcerated since July the 9th. We still have no autopsy report, and
Did the toxicology come back?
it has not. And no fault of the prosecutor's office, but we have not. But we're still back at the same position we were when I first asked for the bond reduction, that he's not been charged with the homicide. And so I think a $1 million cash or surety bond, even understanding that there's an investigation in a homicide, that would be a more than reasonable bond of $1 million cash or surety. And
Counsel,
the court-
I don't want to go back
Okay.
through everything because we've been
I know,
through this over and over, but there are certain parts to this that raise concerns for the court. There is, and I don't know where it comes from. I mean, I'm getting pieces too, but we have the defendant located where this woman's body is found. There is some indication of some drug use and or cocaine. There is then the issue of, and I'll just say what has at least been alleged, deceptive statements by this defendant to law authorities. There is certain evidence that hasn't been turned over, or where there's been some indication of no knowledge of it, where other evidence says he should have it. That being, for example, the suitcase, at least as I understand it. So I have all of those facts, and I mean, I can just put an end to it, and I don't think I got to give a rationale. I'm not lowering this bond.
Okay. I understand.
I'm just not.
Okay.
And if certain facts come in it's not going to be a question of lowering the bond. It may be a question where this court gets to the point where I think the bond may need to be raised, even though not posted.
Okay.
I mean,
Your Honor, you made your position clear. I'm not going to try to continue to argue. The one thing, and we're still working on it, we'll leave it, if the court's decided that it's going to deny the bond motion and leave it at a $2 million cash or surety bond. The last time we were here and I spoke to Ms. Blanche about this, the court indicated that it would modify the bond, that he would be on a GPS tether, but not home confinement. I told Ms. Blanche that I was going to submit an order modifying it, at least to that extent. And then if I can find a bail bonds person to post the bond, that's what I'll do. But I'd like to submit that order. And I spoke to Ms. Blanche and told her before submitting it, I would get her approval. But I don't know if the court recalls, but the court did say if he's able to post the bond, he can work, and I will not require home confinement. I'll just require it to electronic monitoring.
we have. Did the people have a position on that? I'll tell you what the court's position is.
I did, Judge. I objected to him not, my problem is there's obviously potential witnesses at that home where this allegedly occurred or started and where the victim was missing. So I do have an issue with him being confined, particularly to that home, let alone being able to just actively move around the community, not being on home confinement. So yeah, I would object. I think the bond, I would like you to keep it the same as what the magistrate ordered.
I would at least allow, I mean, the court did say that it was last, I don't think it was the last time, the time before, that it would allow him, a GPS would be sufficient, but at least he still has a job. The court got a letter from his employer, Ken Wall Steele, where he's head of the IT, at least allow him to work. And the court did previously rule.
If the bond is posted, certainly the court will take a look that will allow him to work. I mean, if it can be done. I might, given the circumstances, also agree with the people that tethering somebody to allegedly the place where a crime took place and just not knowing the nature of that does cause the court some concern. I don't know that he would have some other place to go. I would presume there would be some other place that he might be able to be tethered to, and that would alleviate that concern. And then the issue of how, if the court saw fit, to allow him leeway on that tether so that he could work. I mean, that's how I had it kind of fashioned in my head, to try to certainly be fair to the people, but also be fair to the people, but also try to be fair to the defendant on some balance should he post the bond.
Your Honor, you did state on the record that you were not going to require the home confinement. You were going to require the GPS, but he couldn't be released from the jail until he's outfitted. I'm prepared to order that transcript, but that's what the court had previously ruled.
That I ruled that?
Yes.
If you order your transcript.
Okay, and I don't think Ms. Blanche disagrees that.
Oh, I don't know exactly.
Okay, I'll order the transcript.
I don't think I've made any ruling per se on this, have left everything where it is. I don't think I've made any particular order. I may have suggested that I might do something.
No, I think you said you actually ruled that you would allow him, if he could post a bond,
Counsel,
as it is.
Counsel, you know how I am. If that's what I said, then I will honor what I said.
Okay.
I don't think that I said that.
Okay.
Because I've not ruled on anything.
Okay.
Because it would have been very easy for me, quite frankly, at the beginning, just to circumvent this whole thing and just deny your motion.
Okay.
I have given leeway to counsel to present everything in the world to me. If I misspoke and granted certain parts of it, then fine. I'll stick with what I said.
Great. I feel confident, but I'll order the transcript and then we'll know.
Do what you got to do.
Thank you, Judge. In terms of the probable cause conference, I've spoken to Ms. Blanche. We would like to put it over for 3 weeks, and that will be the last time.
To the 5th or the 12th? Because the probable cause conferences are on Thursdays. I just happen to be on Tuesdays.
Okay, you said the 5th or the 12th?
Vacation. God, I'm hoping I get to it today.
I think the 5th is fine, Judge.
That will work.
That'll work.
And just so that we're clear, are we expecting that there are going to be reports or other things that are going to be available by that date?
I would hope, Judge. It was supposed to, obviously, we were supposed to know something today, but I think she wanted to not verbally acknowledge anything and have everything right from now on out. So I don't have anything right.
Probable cause conference will be adjourned.
Okay.
September 5th, 2024.
And Your Honor, once I receive the transcript, I'll forward it to the court and to Ms. Bland.
Well, I'll see it. All you have to do is let us know where you think I said it.
Okay. Thank you, Judge.
Understanding that when I look at the whole picture, I could change my mind.
Pardon?
So, no, nothing. Ron, continue.
Okay, thank you.
Thank you.
Okay, so thank you for tuning into this video. Like I told you again, this has been a doozy of a case. The guy's doing all he can, even trying to sell property. And the courts are saying, well, hey, we can't use that property towards his bond. But the property, according to the defendant's lawyer, is worth millions. How do you feel about this case? They're doing all they can to get this gentleman out of jail. And we haven't even heard the trial yet. We don't even know if he did it. But the problem is, when there's smoke, a lot of times there's fire. And that's what the courts is trying to say. No, we don't want to let him out because we think that he's a hardened criminal now. So a lot of people are like, oh, I never did this before. It's no, it was not me kind of thing. But when the courts latch on to you, man, when they get onto your wrists, they don't let you go. So do all you can to walk away when it's situations like this. When the person say they want to move on and you feel that you can't live without that person, right? That can be a scary situation to put yourself in. But I also would say this, protect yourself, man. Because once you do something bad, and just say you in your 50s, and they give you 30 years in jail, that's your whole, that's the rest of your life gone. And then some people say, well, I went through a midlife crisis, I'm 50. Think about it. If you're 50, that means you living to be 100 if you're midlife crisis. Most people are not even getting past 65. So if you're going through a midlife crisis, then 33, 34 kind of area, that's your midlife. For a lot of people, it's your 30s. So people be like, oh, I got the whole life to live. Oh, you heard about John Boy? He was only 58. So that means at 58, right? At 29, that was your midlife. Don't do crimes at a certain age because the rest of your life is gone. Nevertheless, this is Antonio with Team Tiggio. Please like, comment, subscribe. As we'll keep pumping out these videos on this channel. And once again, we'll see you.